Yes,
May
please.
loss.
Yes.
Two items, my lord, I want to mention for 24th. Next Monday.
For what?
One is, my lord, very urgent regarding the medical college Jorhat.
Motion.
And another is, my lord, for orders regarding Gram Panchayat, Gram Pradhan. 24th.
24th, I can't give you both matters because the list has to be spread out.
Then what 26th
So,
one?
I can give you first week of April.
Both the
First week of, yes. First week of April. Registry will fix the date. Yes.
May please, item number 21. I'm making mention on behalf of PJ Fukon, my lord. He is
Yes.
absent today, my lord. So I will take it any other day.
Item number?
21. PJ on behalf of PJ.
Yeah, the other side has been informed.
Yes, my lord. He has taken consent.
All right. On the request of learned counsel for the lead petitioner, made with the consent of the other side, admission hearing of this matter stands adjourned for 2 weeks. May I please, PJ Fukon is appearing for respondent.
Yes, my lord.
The petitioner is also PJ Fukon.
I think petition are there, my lord. Yeah.
Huh?
Then here petition are there, I think.
Pollution Control Board.
Achha,
Notice nahi done.
for the respondent number,
I don't know. On behalf of the.
then when the matter is called up, you make a mention. You have to give the minimum information to the court. How do we write an order?
May I please, your lordship? Lordship, I pray for listing of this matter for withdrawal, my lord. Writ petition.
When do you want?
Can it be day after tomorrow, lordship?
Yes.
Much obliged.
I motion matter mila, fresh matter mila. So I filed it on 12th of March.
What is the matter about?
Regarding the appointment of regarding Anganwadi worker. matter.
It will come. What is the urgency? Why are you mentioning?
They are trying to appoint some other person outside the civil. If the appointment is male, then the another problem is. That is even my privilege. It may come on 19 or 23.
19.
Must.
This pension matter may be listed for admission on 2nd of April, my lord. Pension matter, man. 2nd of April. Obliged.
May it please your lordship, I beg to mention for listing an IF first time lordship for Friday lordship. Obliged.
May I please, your lordship, with the consent of other side, lordship, I beg to mention item number 32. Here, I require some time to file my affidavit, lordship. I have taken the consent. 32.
Item number?
32.
On the prayer of Mr. S.S. Roy, learned CGC made with the consent of the other side, admission hearing of this matter stands adjourned for 3 weeks so as to enable him to file affidavit.
Lordship.
May I please, your lordship, I beg to mention for listing a matter lordship for 19 lordship. The matter is relating to promotion lordship.
Huh?
The matter is relating to promotion lordship.
No promotion, there is no urgency. You go and make an application request to the.
He made the application lordship.
No, then 2nd week of April. 2nd week of April.
Lordship 25.
Rejected.
Petition are.
I wrote it correctly.
Item number 21. For the petition.
So I petitioner will require again. PJ Fukon is the counsel for the petitioner.
Yes, ma'am.
The original orders.
With consent of the other side, my lord, I beg to mention item number 43, my lord. I am appearing on behalf of respondent number 2, 3, and 4, APDCL, my lord. Here, my lord, instruction are awaited, my lord. Kindly.
You have informed the other side.
Yes,
With the consent of the opposite side, the learned standing counsel for APDCL 6 adjournment in this case for 3 weeks for obtaining instruction. Prayer is allowed. List the matter accordingly. Item 43, is it?
43, my lord.
Yes.
Much.
May it please your lordship, I beg to mention item 34 lordship. It may be listed after 1 week lordship. As the engaged counsel, Mr. Edas, is out of station
On
lordship.
the prayer of learned counsel for the petitioner, this matter stands adjourned for a week. Yes.
Your lordship, my lord, this is municipalities matter. My lord, financial year is ending. Now we have to issue tender notice. We are due to filing a case by a false party. We have been deprived from issuing tender. So urgency is there. It can be listed.
What? It means what? It means what?
It means when tender, we cannot issue tender because of the nature of this case. Right?
What do you want to be listed?
We want this case to be listed for the purpose that status quo order should be vacated.
Have you filed an IA?
It was already, there is a order that after 2 weeks it should be listed, but since last 8 weeks it is not listed.
No. Is there a IA to vacate the?
No, IA has not
Then
yet
sorry, it can't be done. You have to file an IA, then we'll take it up. Yes.
May I please, your lordship, I'd like to mention for listing of one matter for withdrawal, lordship.
When do you want?
Day after tomorrow,
All right.
if you
Yeah, please, your lordship. My lord, I beg to mention item number 35, my lord.
Hmm.
It may be allowed to withdraw. I'm doing. Item 35.
Item 35, on the request of Mr. F.A. Lashkar, Learned Counsel for the, why it has, order has been complied with?
No, my lord, this is a compassionate appointment, my lord, and new notification has come. So therefore it is, this
Mr. F.A. Lashkar, you are AY,
FS.
F. Lashkar, Learned Counsel for the petitioner submits that in view of the recent notification dated 8/9/2024, the order involved in this proceeding cannot be complied with. As such, the contempt case be closed. Taking note of the submission of Mr. Lashkar, this contempt case is hereby closed.
Release of family pension, my lord. In this case, I was directed to file, my lord, affidavit reply. I have already filed. It was last listed on 6/5/24. Release of family pension, my lord. So matter may come subject to election.
Matter may come when? Tomorrow?
No, my lord.
Then?
Any date, my lord.
After 2 weeks.
May it please your lordship, this is for the withdrawal of item number 52, your lordship. This is regarding transfer, but now the petitioner has already retired, your lordship. So
Item number
52, your lordship.
52. WPC 2178.
Yes, your lordship.
You are for the petitioner.
Yes, your lordship.
What is your name?
B. Soren, your lordship. My name is not reflected as I'm appearing on behalf of Senior Counsel BD Core, your lordship.
Mr. H. Agarwal, Learned Counsel for the petitioner submits that during the pendency of this proceeding, his client has already retired from service. Stop. As such, the prayer made in the writ petition has become infructuous. In view of the submission made by the petitioner's counsel, this writ petition stands disposed of as infructuous. Interim order, if any, shall stand vacated. Consequently, IA number so and so shall stand disposed.
Oblige, your lordship.
Daily list for motion item 1.
May I please, your lordship?
Yes.
My lord, petitioner, my lord, is a chief medical officer selection grade in the border security force, my lord. As per rule, my lord, the seniority of a direct recruit shall be maintained as per the merit list. But here in the case of the petitioner, my lord, although the petitioner is appearing before the private respondent here, my lord, but in the merit list, my lord. But while updating the seniority list, my lord, the juniors to the petitioners were updated over the, my lord, petitioner, my lord, were granted seniority over the petitioner, my lord. That is the case here.
It is a process based on merit.
Merit list, my lord.
So if they are better merit, then they will be upgraded. What is the problem with it?
No. I am having the better merit list over the private respondent, my lord.
Show that.
Lordship. Page number 33 is the merit list, my lord. Lordship will find, my lord. Even, my lord, I submitted representation from time to time, and some of the respondent, my lord, the officers, my lord, they have also considered my representation, and even they have also admitted that yes.
Please don't go here and there. Show me where is.
My lord. Page number 34 is the relevant relevant page, my lord. This is the employment list, my lord, where the merit list was published.
You did not initially implement the private respondent.
Yes,
Subsequently, it has been done.
My lord.
How many private respondents?
Total, my lord, 36, 30, my lord, 35, my lord, 36, 35, my lord.
35. 1 to 5 official.
Test.
The amended cost title is it there? Yes.
My lord.
Just see if the amended cost title is here. I don't find it. I find only 5 respondents here. Promotion to which post?
To Director General, DIG, my lord.
DIG.
Deputy Inspector General Medical, my lord. Usually he is working as a commandant, my lord. Now the next promotion will be to, my lord, DIG, my lord. So, my lord, it is all India basis, my lord, seniority list. Earlier, my lord, department was seniority list was maintained, but after 2020, my lord, my lord, all India, my lord, combined senior.
Oh, please focus on the petition. Where is the amended cost title with the respondent's name?
Not in this page. Yes, my lord, here, my lord. The first flag, my lord, the flag mark is here, my lord. My lord, rule specifically say, my lord, the rule say the seniority of a direct recruit, my lord, shall be maintained as per merit list. There is a, my lord, government instruction also. The government instruction also say, my lord, the memorandum, my lord, that was issued by the Department of Personnel and Training, Government of India, my lord. That, my lord, departmental instruction also say, my lord, the seniority of a direct recruit shall be maintained as per.
Notice you file your affidavit.
My lord,
Notice, my-
1 to 5, I can, my lord, others, my lord, from 6 to 40. My lord, directly I cannot, my lord.
No, no, here, take steps.
My lord.
My lord, here,
Two
I
to one.
clear one thing, my lord, here. It's a very voluminous petition, my lord, more than 300, most probably 350.
No, but you have to take steps. This through the officer is not a mode of service.
One he has given, my lord, to the, through the additional, that is the medical.
It is a medical, my lord. He is the
He can
ultimate authority.
push the authority, but directly I cannot, my lord, take, on private respondent, I cannot.
Service of notice, the mode and mannerism is
My lord,
laid down, correct?
my lord,
You cannot jump it and take another mode.
my lord.
If the regular mode is not effective and it doesn't yield result, then the court can think of an alternative. But you cannot say that I will not take steps.
Lordship, lordship.
That you cannot say.
Mal-
Even if it is voluminous, there is no way out.
My lord.
Or Mr. M.A. Islam, counsel for the petitioner, peruse the amendments made in the writ petition. They complain, the basic complaint in this writ petition pertains to alleged supersession of the petitioner by his juniors, who are the respondent numbers 6 to 40 in this case. First up. According to Mr. Islam, although the petitioner is more meritorious and senior to the private respondents, he has been overlooked for promotion to the next higher rank of DIG
My lord.
in the border security force bracket BSF. Issue notice returnable in 6 weeks. Since Mr. K.K. Parasal Lanet CGC has appeared and accepted notice for respondent numbers 1 to 3. Service of notice on the said respondents is deemed to be complete in this case. Extra copies of the writ petition, requisite in numbers be furnished to the Lanet CGC. Petitioner to take steps for service of notice upon respondent number 6 to 40 by registered post with AD.
My lord.
You take steps, then we'll see.
My lord. Ali, Ali.
Item 2.
Anybody appearing? I have a passport for the time.
3.
Passport.
Item 4.
Your lordship,
Yes.
my lord, this matter relates to family pension, my lord. Instruction was sought on the last occasion.
We have received the instructions, Your Lordship.
Yes.
The instruction says that the petitioner, she was asked on 2 occasions after the death of the petitioner's relative to submit the documents relating to pension papers. But till that, she has not submitted the papers. That's why it could not be paid. We have written to her. I have got the letter, copy of the letters also. We have written to her on 28th of August, and then again in December, submit all the certificates, death certificates, legal heir certificates, all these documents, but nothing has been submitted.
So you furnish the documents,
Yes, my lord.
then we'll close it. Where is the instruction? All right. Take down. Heard Mrs. V. Chaudhary and counsel for the petitioner. Also heard Mr. D. Vora, learned government advocate Assam, appearing for the state. Mr. P. Nayak, learned standing counsel, finance department, is present on behalf of the respondent number
Six.
six, and Mr. S.K. Mehdi for respondent number 5.
1 to 4.
1 to 4. Hold it. 1 to 4. Full stop. The deceased husband of the petitioner was serving as a constable under the Assam State Reserve Force. Full stop. He expired on 18/8/2024. Since the deceased husband of the petitioner was entitled to receive pension, hence the petitioner had applied for pension, full stop, alleging that her application has not been acted upon till date. The petitioner has approached this court by filing the instant writ petition, full stop. In terms of the order, next paragraph, in terms of the order dated 10/2/2025, Mr. D. Bora, learned government advocate Assam, has obtained instruction and placed this written instruction and placed the same before the court. As per the written instruction dated 15/02/2025, issued by the commandant of AISF Battalion BN dash capital Roman 1, Baharbari, Sonitpur. It is admitted that the petitioner did make a representation on 16/12/2024 through email seeking pension, but she did not submit any of the necessary and relevant documents, as a result of which her claim could not be processed. Responding to the above, Ms. Chaudhary, learned counsel for the petitioner, submits that if that is the issue, then her client will definitely submit the necessary documents within 3 weeks from today. Full stop. Mr. Bora has submitted that once the documents are received, the claim of the petitioner for release of family pension will be processed in accordance with law. Taking note of such submission made at the bar and with the consent of both the sides, this writ petition stands disposed of by providing that within 3 weeks from today, the necessary documents as mentioned in the parawise comments written instruction dated 15/2/2025 be furnished by the petitioner before the appropriate authority. Upon receipt of the same, her claim for grant of family pension be processed as expeditiously as possible and brought to its logical end. With the above observation, the writ petition stands disposed. Copy of the parawise comments written instruction be retained in the record of this case. Have you seen this parawise? Will you show it to her once?
That's right.
There are 11 documents. You can take a photo, picture, and tell your clients to give it. Yes.
Item 5.
May it please your lord.
Yes.
And the matter pertains to continuation of suspension without any review. Lordship will kindly pay the order dated 28/2/25.
Yes, 1 year, 7 months suspension. Yes.
Yes, my lord, the instruction is awaited. Though my lord, inquiry is held, my lord. Show cause issued, my lord, and inquiry, my lord, started, my lord. That is there, my lord. But my lord,
yes,
he has twofold prayer, my lord. One is subsistence allowance of 70%, and the second is reinstatement, my lord. My lord, today I will pray, my lord, that my lord may issue notice, my lord. We will file an affidavit, short time, my lord, and my lord may direct regarding this subsistence allowance, my lord, because that is he is entitled, my lord, to get it, my lord. One part let him take, the rest, my lord, I'm coming with an affidavit, my lord. Once the notice goes, my lord.
Let him file affidavit, my lord, but his passing day is illegal suspension, my lord. In view of Ajay Chaudhary.
No, what do you say in response to his submission?
No,
Subsistence allowance or direction can be issued today itself, he says.
subsistence and enhanced subsistence allowance is not been there. What I'm saying, lordship can stay the suspension order.
No, suspension cannot be stayed. It will be set aside or it will be maintained.
And that's
There is
what-
no suspension stay.
Yes, my lord, then I
Doesn't arise.
humbly pray that my lord, since they have already taken 2 days, a short date may be given to file affidavit. Because each passing day, my lord, illegal.
I understand.
Yes, ma'am.
So we'll issue a short notice and fix
Notice,
it for
ma'am.
disposal.
My
It is up to you. If you don't file affidavit,
my lord,
we'll proceed as per the materials. on
I
record.
understand, my lord.
Heard Mr. J. Patori, learned counsel for the writ petitioner, also heard Mr. R. Dhar, learned
Additional senior.
government advocate Assam, appearing for the respond numbers
2, 3, my lord, 2 and 3, my lord.
2 and 3. Mr. J. Henley, learned standing counsel, Revenue Department, Government of Assam, is present on behalf of the respond number 1. In terms of the order dated 7/3/2025, this matter is posted today for motion hearing, so as to enable the learned departmental counsel to obtain instruction. However, despite 2 opportunities granted for the purpose by this court, Mr. Dhar submits that the instructions are still awaited. Full stop. The grievance of the petitioner expressed in this writ petition are twofold. Stop. Firstly, it is a case of prolonged suspension without following the due process of law, thus rendering the order of suspension as illegal. Full stop. Secondly, the petitioner has not been paid the subsistence allowance for the period of suspension already undergone. Full stop. Mr. Dhar, learned government advocate Assam, submits that insofar as subsistence allowance is concerned, he would have no objection if a direction is issued by this court to release the subsistence allowance due and payable to the petitioner without any further delay. However, insofar as the other grievance is concerned, he be granted 2 weeks time to file an affidavit, placing the stand of the department on record. Full stop. Similar is the submission of Mr. Hendick. Taking note of submission of the learned departmental counsel, this court is of the view that the matter would call for further examination. Issue notice of motion returnable on 4th of April 2025. Since the respondents are already represented, no formal notice is required to be sent in this case. Extra copies of the writ petition requisite in numbers be furnished to the learned. Who is appearing for whom?
My lord, for 1. And 2 and 3, I am appearing, my lord.
Already appearing, no formal extra copies. This writ petition will be posted for admission hearing as a fixed item on 4/4/2025. If the respondents fail to file their affidavit on or before the next date fixed, the writ petition will be taken up for disposal based on the materials available on record. The respondents are also directed to release the subsistence allowance due and payable to the petitioner as per the applicable rates within 2 weeks from today and submit compliance report.
And just one, my lord, subsistence allowance at the rate 50% is being paid, but enhanced subsistence allowance is not paid. I am entitled to
As
70.
per the applicable, that's what is being paid.
Deeply aware.
But there's a transfer matter, my lord. Lordship was pleased to direct them.
Yes. What is your instruction, Mr. Datta?
My lord. My lord, earlier there was a case, my lord. On that case, my lord, status quo was directed.
Mr. Datta,
My
listen.
lord.
We'll go to other things. You will always be given opportunity to argue, but you must first address the query of the court.
My lord,
This is a trend I am seeing, which is very.
my lord.
The question on which the matter was adjourned is there any policy decision, any notification rule which permits inter-district transfer of contractual employees? If the answer is yes, show it. If it is no, we'll
My
stay
lord,
the order.
there is no specific.
Then we'll stay the order. Rest you submit. Because contractual, you cannot transfer like this.
My lord.
It becomes completely arbitrary exercise of power. That will not permit. There is nothing else.
My lord, we'll
Yes.
file affidavit, my lord.
You
Lordship
file
may
affidavit.
say yes. my
Yes. Where is the impugned order?
My lord,
You have understood the point?
Yes, 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 my lord.
Yes.
Page 28 and extra 7.
Page 28.
Yes, please.
Yes. Heard Mr. H. M. Moore, counsel for the writ petitioner, peruse the amendments made in the writ petition. By filing this petition, petitioner has challenged the transfer order dated 20/02/2025, by means of which he was transferred and posted at Dogao, Dhingao, GP, under Juria Development Block, Nogao. Full stop. The writ petitioner was earlier engaged. Achha, where is that 9/9/2024? Order dated 9/9/2024.
Page 26, man.
Yes.
No, he had earlier challenged another transfer order,
Yes, my
Yes,
lord.
14/10.
Yes. That, in that case, my lord, his ground was that, my lord, within 3 years, he was transferred. That is
Right.
why that is become infractions, my lord.
The writ petitioner was originally engaged as
Gram Rozgar Sahayak.
Gram Rozgar Sahayak on contractual basis under the Bamungao GP, coming under Odali Development Block, Hojai. Full stop. The order of transfer has been put under challenge primarily on the ground that, being a contractual employee, his job was not transferable. Full stop. The petitioner had earlier approached this court by filing WPC number 4482/2020, challenging a similar transfer order issued on 14/10/2020. The said writ petition was closed by order dated 9/9/2024 by holding that the writ petition, that due to efflux of time, the writ petition has become infructuous. Be that as it may, taking note of the grievance of the petitioner, this court, wide order dated 10/3/2025, had asked the learned departmental counsel to obtain instruction and appraise this court as to whether the service of the petitioner, service of contractual employees such as the petitioner, was transferable, and if so, the relevant provision of the contract rule policy decision, if any, permitting inter-district transfer of such contractual employees be placed before the court. Stop. Today, when the matter is called up, Mr. Datta submits that there is no such.
Lordship, can it be some modification, my lord? Unofficially, I have not received any instruction yet. Actually, I have not found, my lord. With the officials, I have also discussed, my lord. That may be kept open, my lord. For if any there, we will file affidavit later
All
on.
right. Mr. Datta, learned standing counsel for the PNRD department, submits that although submits that he is yet to receive any instruction, and therefore seeks further 4 weeks time to obtain instruction and file affidavit. In view of the above, issue notice of motion returnable in 6 weeks. Since Mr. Datta has appeared and accepted notice on behalf of respondent number 1 to 4,
All the responses.
no further notice is required to be sent in this case. Extra copies of the writ petition be furnished to the learned departmental counsel. Requisite in numbers, so requisite in numbers so as to enable him to obtain instruction. Heard on the prayer of interim relief, having regard to the overall facts and circumstances of the case, the operation of the transfer order dated 20/02/2025, bracket annexure 7, shall stand suspended till the returnable date. List again on 23rd of April.
Item 7.
May I please the lordship, matter relating to release the post-retirement benefit as deposited by the petitioner lordship.
So we'll issue notice.
Lordship.
Heard Mr. P.K. Gogoi, learned counsel appearing for the petitioner, peruse the amendments made in the writ petition. The grievance expressed in the writ petition pertains to non-release of retirement benefits which the petitioner claims to be entitled to. Issue notice of motion returnable in 6 weeks. Petitioner to take steps for service upon the respondent.
I level.
Registered post.
May I please? Lordship, in this case, petitioner submitted a representation for cancelling his transfer order, lordship. I impugned order, lordship, page 50 and exact 12, they have rejected his representation on the ground that his wife is also doctor, lordship. On this spouse ground, lordship, there is a specific guideline, we have annexed the guideline, lordship, they have did not consider the same guidelines, lordship. Office memorandum
What
is
is,
there.
what is the ground? Why transfer? You are in a transfer.
Lordship, on the
You have-
spouse ground, lordship, my 1 year children is there, lordship.
Oh,
My-
they will not be.
My wife is also doctor, lordship. And there is a guideline, lordship, on this spouse ground, the wife and husband should be posted in the same place, central government as well as state government, our state government also, lordship, there is a office memorandum.
That you have made a representation.
I have
What has
already,
happened? You
they have
disposed it of.
rejected my
Yes,
representation.
My lord, on that ground, the wife may file a application because the petitioner has been transferred, because he is a specialist doctor, my lord. So he has been transferred to a civil hospital, my lord, and order.
Let the wife.
They have rejected
Yes.
my representation, I have already.
That's
filed.
right. He's saying let the wife file a representation to transfer her along with the husband.
Yes, my lord.
Everybody wants convenience.
In the meantime, lordship,
You are now approaching the court to enforce your convenience, not right. Hmm.
there is a specific office memorandum, lordship,
All right, we'll issue notice, but no stay.
Yes.
Heard Mr. A.V.T. Hawk, learned counsel for the writ petitioner. Peruse the amendments made in the writ petition. The notification dated 02/01/2024, bracket annexure 4, by means of which the writ petitioner was transferred from Sonabari Ghat SHC Kachar and posted as medical and health officer M&HO at the SK Roy Civil Hospital, Hailakandi, has been put under challenge. The primary grounds on which the challenge is made is on account of the fact that the wife of the petitioner is also a doctor and he has served only for a year in the present place of posting. Mr. Boran, learned DP Boran, learned standing counsel, Health and Family Welfare Department submits that the transfer of the petitioner is necessitated on account of the fact that being a specialist, his services are required at the SK Roy Civil Hospital, Hailakandi, full stop. However, if the petitioner is seeking posting at the same place along with his spouse, then it will be open for the wife of the petitioner to make such a prayer before the authorities. Full stop. Having heard the learned counsel for both the sides and on perusal of the materials on record, I am of the view that there is no justifiable ground for this court to interfere with the transfer order issued to the petitioner. Full stop. Law is well settled that the guidelines issued by the government for affecting transfer of employees are directory in nature and in the existences of, and those cannot be enforced in a court of law. Full stop. In the existences of public service, it would always be open for the authorities to transfer an employee from one post to another. Full stop. Transfer being an incident of service, such a transfer order cannot be questioned merely on the ground of violation of the guidelines. Full stop. Unless there is a categorical plea of violation of statutory rights or malafide exercise of power, the writ court would not normally interfere with the order of an order of transfer. Full stop. Under such circumstances, I do not find any justifiable ground to entertain the writ petition. The same is accordingly dismissed. It would, however, be open for the wife of the petitioner to seek her transfer at the same place of posting with her husband by moving the concerned authorities if so advised. You tell her to fight.
My lord, another writ petition 98 of 2025.
That, what is there in it? That
My
becomes
lord,
an infraction.
initially transfer order was challenged, my lord. Subsequently, the speaking order has been challenged in this.
All right, so in view of order passed here, that becomes infraction.
Yes, my lord, that has become
So and so for the petitioner, so and so for the department, in view of order passed in so and so, the writ petition has become infractious, the same is accordingly closed.
Yes, my lord.
The other one, which is the other? Which is the other case where speaking order is under challenge? Item number?
Supplemental, which is item 38.
Sure. Just 1 minute. Item 56. Achha, you are not the, you are the counsel there.
I am the counsel.
And Mr. Talukdar is also there.
He is representing me, Lordship.
Huh?
He is my senior counsel in this case.
All right, so that is closed. Please inform him. Item 56.
Item 9.
Yes. Yes,
Mr.
Mr. Das.
Look, this is the matter pertaining to departmental proceeding. Penalty of compulsory retirement from service was imposed upon the petitioner. He preferred an appeal got rejected. The allegations are, my lord, sexual harassment at workplace. We have challenged the departmental proceeding on the ground of procedural violations as well as perversity. Procedural violations is that now it is the mandate that in such matters there is to be a ICC, and the enquiry by the ICC will be equivalent to the enquiry under the service rule. Now, in here, my lord, the disciplinary authority followed a totally divergent procedure. First, they issued a show cause notice. Thereafter, they constituted ICC. Thereafter, the ICC decision came. Thereafter, an inquiry. Inquiry officer recorded finding that I cannot derive any conclusion because there is no evidence. Now, the disciplinary authority disagreed with the finding of the inquiry officer and, my lord, imposed penalty relying on a finding given by the ICC that I have sought apology from the, my lord, complainant. My lord, that apology was, my lord, a generous apology by my fellow colleague with a rider that those two videos got transferred from the mobile phone of the petitioner inadvertently. He sought apology as a generous person, my lord, that these two videos got transferred from my mobile phone inadvertently. But the disciplinary authority, relying on the ICC's finding, imposed the penalty of compulsory retirement.
So it is not permissible.
It's not permissible, my lord. Because
Are
then
you
why-
sure? Because the ICC is now after amendment of the
Yes,
CCS.
my lord, what happens, my lord, after the ICC's finding, my lord, here they have jumbled up everything. After the ICC's finding, there should not have been any inquiry by the department. ICC's report comes, the disciplinary authority is free to take a call on that. Here, my lord, what they have done, they have conducted a departmental inquiry, separate departmental inquiry. And that particular inquiry, my lord, gave a finding that we cannot come to any conclusion because there is lack of evidence, my lord. The disciplinary authority disagreed with that finding of the inquiry officer and gave his own finding by relying on the report of ICC. That is on, my lord, procedural side. And so far as, my lord, on merits also, my lord, it's an admitted factual position as well as my stand from the very beginning that those two videos got transferred inadvertently from my cell phone, my lord. Then on 15, those got transferred. The complainant opened on 24 of 12. After almost.
All right, so the matter will have to be examined.
Examined, my lord.
So we'll issue notice at this stage.
My lord.
Heard Mr. H.K. Das, Learned Counsel, appearing for the writ petitioner, peruse the statements made in the writ petition. In this petition, the order dated 19/7/2024, by means of which major penalty of compulsory retirement from service was imposed upon the petitioner, has been put under challenge. According to Mr. Das, the impugned order is vitiated due to impugned order dated 19/7/2024 is vitiated due to procedural irregularities. Moreover, according to Mr. Das, the allegation brought against the petitioner has not also been conclusively proved. Ms. M. Bhattacharya, learned additional senior government advocate Assam, appearing for the state, prays for some time to seek instruction and file affidavit. In view of the above, issue notice of motion returnable in 6 weeks. Since Ms. Bhattacharya has appeared and accepted notice for all the respondents, no formal notice is required to be sent in this case. Extra copies of the petition, requisite in numbers be furnished to the learned departmental council with one being complete.
Item 10.
Yes.
Lordship, by this writ petition, I have challenged the departmental proceedings conducted against me, and pursuant to which I have been removed from the service by the impugned order dated 3/7/24, and also the dismissal of appeal by the appellate authority on 7/1/2025. So there are several illegalities have been committed during the entire process by the inquiry officer, by the disciplinary authority, by the appellate authority.
Notice may be issued.
All right. Heard Mr.
R.K. Sarma.
R.K. Saranya, learned counsel for the writ petitioner, peruse the averments made in the writ petition. The order dated 3/7/2024, by means of which major penalty of dismissal from service.
Removal from service.
Dismissal from service.
Removal from service.
Removal from service was imposed upon the writ petitioner has been put, has inter alia been put under challenge in this writ petition. Mr.
A. Dhanuka.
A. Dhanuka, learned counsel appearing for the respondents. Respondent bank. You are the standing counsel.
No, Lordship. Mr. A. Ganguly is standing counsel. I am appearing on behalf of him.
Appearing for the respondent banks. Then whose name should I record?
A. Ganguly, Lordship.
Mr. A. Ganguly, learned standing counsel for the respondent bank, has appeared and accepted notice, appeared and sought for some time to obtain instruction. In view of the above, issue notice of motion returnable in 6 weeks. Since Mr. Ganguly has accepted notice for respondent numbers 1 to 4, no formal notice is required to be sent to the said respondents. Extra copies of the writ petition, requisite in numbers, be furnished to the learned departmental council. Petitioner takes steps for service of notice upon respondent number 5 by registered post to Delhi. Respondent number 5, you take steps.
Deeply obliged.
Item 11.
May it please your lordship. Matter pertains to area salary of the petitioner lordship. So petitioner is initially appointed as medical and health officer on 10 December 1985. Thereafter, his service was regularized on 10/7/1986. Lordship, he is promoted to the senior medical and health officer on 6/5/2013. And for the salary, lordship, that year retention order is necessary. But in the next year, what happened? Ex post facto retention order has been submitted with the for area salary that is amounting to ₹19 lakhs, lordship. And he has obtained, he got 12 lakhs, but remaining 7 lakhs is till, he has not get till today, lordship. And this is only because ex post facto retention order has been submitted.
Will issue notice?
Yes, please.
Heard Mrs. K. A. Pujari, learned counsel appearing for the writ petitioner, peruse the averments made in the writ petition. The petitioner has retired from service as SDM and HO on attaining this age of superannuation with effect from, when did he retire?
31/5/2015.
31/5/2015. The grievance of the petitioner expressed in this writ petition is that owing to some departmental lapses an amount of rupees 7,12,933 as area salary and allowances payable to the petitioner pertaining to the period from 1/1/2013 to 28/02/2014 has not been released by the authorities till date. Hence this writ petition. Mr. D. Upamanu, learned standing counsel for the Health and Family Welfare Department, Assam.
1 and
Waits
2.
for some time to obtain instructions. NOM 6 weeks. You are for respond numbers?
1 and 2, Lordship.
Mr. Upamanu has appeared and accepted notice for respond numbers 1 and 2. Mr. P. Nayak, learned SC Finance for respond number 3. And Mr. R.K. Talukdar, learned standing counsel AG Assam for respond number 4. Service of notice is deemed to be complete in this case. Extra copy of the petition be furnished to the learned Departmental Council office to list the matter again by showing the name of the respondent's counsel in the cause list.
Much obliged.
Item 12.
Yes, Your Lordship. The promotion matter, my lord. The petitioner has been deprived from the promotion to the rank of Subedar GD, my lord. He was intimated that due to the lack of ACR, his name was not.
By Mr. V. Kumar, learned counsel for the petitioner. The grievance of the petitioner is that he has been deprived from promotion to the rank of
Subedar GD, my lord.
Subedar GD, despite being eligible for the same. Ms. B. Sharma, learned CGC, appearing for the respondent's place for some time to obtain instruction in the matter. Issue notice returnable in 6 weeks. Since Ms. Sharma has appeared and accepted notice for all the respondents, no formal notice, extra copies.
Item 13.
My pleasure. Impugn order is at my lord. Annexure B page 16 suspended pending royal departmental proceeding, my lord. But on the same day, my lord, the so-called notice also issued and the inquiry officer also, my lord, engaged, my lord, which ought to have, my lord, done.
What is wrong with that? You want them to do it slowly, slowly.
That, my lord, as per rule 9494, my lord, it ought to have engaged after, my lord, filing of so-called reply of so-called. And my lord, already 90 days has passed, my lord, without extension, my lord. And my lord, this statement of allegation has been given, my lord, without, my lord, giving the list of document, list of witness. Everything is, my lord, is a chaotic, my lord.
No, but what exactly are you challenging here?
My lord,
Nothing.
it's not extended, my lord, after 90, even after 90 days, my lord. Main ground of challenge is that A, B, C, my lord, on 510. All everything is on 510, my lord.
Prayer is not to reinstate, my lord.
Huh?
Page number 11 is the prayer of the petition. Prayer is not to reinstate, my lord. Prayer is only so-called notice they have silence. Petitioner has silence, my lord.
No.
At this
Alright,
case, notice may be issued, my lord.
Notice will issue.
Suspension to be set as only.
No, but he has to
No,
obtain.
yes.
Mr. C. Goswami, learned
Short
counsel,
notice.
writ petitioner, there is the amendments made in the writ petition. By filing this petition, the order dated 5/10/2024, by means of which the petitioner was placed under suspension and departmental proceeding was initiated against him, has been put under challenge. Full stop. The primary ground urged by the petitioner's counsel is that the order of suspension of the petitioner has not been reviewed after the expiry of 90 days. Full stop. And therefore, full stop. Therefore, the said order has lapsed by operation of law. Full stop. Mr. S. Datta, learned standing counsel, PNRD Assam, prays for 2 weeks' time to obtain instruction. Issue notice of motion returnable on 9th of April 2025. Since Mr. Datta has appeared and accepted notice for all the respondents.
No, my lord.
Then
For 4, my lord, my colleague is appearing.
actually 1, 2, 3, and 5, and Mr. CKS Burua, learned G. Assam for respondent number 4. Service of notice is deemed to be complete in this case. Extra copies of the writ petition, requisite in numbers be furnished to the learned departmental council so as to enable them to obtain instruction. On the returnable date, the learned departmental council to obtain specific instruction as to whether the order of suspension of the petitioner was reviewed prior to expiry of 90 days, and if so, the relevant records be produced before this court. List accordingly.
My lord, in this case, my lord, petitioner approached your lordship, my lord, to recover that matter excess payment of my lord risks and hardship allowances.
Similar orders are there.
But I will take instruction, lordship, because this order is of December 24. So I will take instruction on Friday. It may be taken.
Your lordship, my lord, passed and similar order.
You said the court has passed order. She said she wants to take instruction. So how much time you want?
Friday, lordship.
Huh?
Friday.
Right. Mr. Ellen Dehinger, my counsel for the petitioner is present on the request of Ms. R. Devi, Leonard CGC, appearing for the respondents. This matter is directed to be listed again on Friday, that is 21st of March 2025 for motion, so as to enable her to obtain instruction. Obtain preliminary instruction.
Pending motion matters item 2.
None appears for the writ petitioner even on the second call. This matter stands adjourned for 3 weeks.
Item 3.
Same order.
Item order stay vacating item 7.
Lordship, I am appearing on VC and I am grateful Lordship granted permission to appear on VC. This is for item number 15, 16, 17, Lordship. These are they are all officers of the finance department, broadly almost identical. The issues here are, Lordship, 2 officers, or in the case specifically, item 15 and 16 are from the 2013 batch of the APSC, Lordship, and 17 is 2014. The 3 IAs that we have filed are for vacation of stay of the orders passed by this honorable court, Lordship. I will deal with Lordship's permission on the first matter, item 15.
So, Mr. Kohli, if you are asking for an order on merit, that's not going to be possible.
Obviously.
I'm not hearing the matter through VC. The only thing that can be agreed on today is when we can have the matter physically.
Yes, they can file their reply shortest date. I mean, if it can be even Lordship, we are coming to Guwahati, in fact, even before Lordship in one of the dates in the near future.
You agree? You agree?
So, I mean, Lordship, 27th or 7th April, whatever works, Lordship, they must file their reply also by then.
7th April? 7th April?
My lord, may I say this? My lord?
Other matters are fixed, I think, sometime.
Yes, I beg to appear for the writ petitioners, my lord, both the writ petitioners in item 15 and 16, my lords. This is, my lord, an application seeking vacation of the interim order, my lords. And, my lords, they have also filed an affidavit in opposition, my lords. All these were served upon us on 6th March. But permit me some time to file a reply, my lord. Your lordships will allow me to file my affidavit in reply to the affidavit in opposition and a detailed reply to the IA, my lords.
That's what we're thinking.
Yes, my lord. So what I'm saying is the lordships will list it after the view vacations.
Lordship, I will oppose that because they are enjoying a stay, Lordship. So therefore, I am pressing for, I think, Lordship, we can argue the stay.
For an order passed in December.
Just to assist,
my learned friend moves in March.
Maybe. And Lordship, that is not an argument because we are here after the state has asked us to agitate it.
I am only asking for the adequate opportunity from my lord.
We are on the vacation.
All I am saying is, my lord, permit me to file a reply.
So you, both the senior counsel, realize what you are putting a judge into.
I'm sorry, my lord. I'm very sorry.
Because there is chaos over.
I agree, my lord.
Matters through VC.
I understand.
Real torture to the judge.
Lordship, I apologize immediately.
So if you want to continue with the torture.
No, my lord, no, not at all.
I, Lordship, apologize immediately.
All I am saying
is, I'm equally vocally.
All I am saying is, my lord, my friends, for consent to, my lord, give me adequate time to file my reply. Your lordships will list the application and allow me also to file my affidavit in reply to the affidavit in opposition.
So,
keep it after
Mr. Chaudhary, I appreciate your concerns and difficulties, but once there is a stay vacating application, we can't defer it for so long. Therefore, it will not be possible. You can choose either 7th or any other date.
Your lordship listed immediately after the view vacation. Immediately after the view vacation.
So make a request when the matter is listed on 7th. That day we'll consider.
I need some, what I'm saying is I need some time to file my reply, my lord. That's all, my lords.
You may need, but we
A
can.
stay vacation application, my lord, just give me 2 minutes.
Once there is a stay vacating application, we are not considering it today. We can't just defer it for 6 weeks straight away. That's not the practice in this court. So stay vacating means they have some urgency. We may allow it, we may not allow it, but we cannot put it for 6 weeks altogether. You file your response in the stay vacating application. We'll either allow it or dismiss it.
Very well. Then, my lords, for my affidavit and
Our
reply,
plans, your
lordship will give me 4
strategies
weeks
may
time.
be valid for you, but we also have to go by the
No, I
law.
agree, my lord. I don't want to, my lord, defer anything. my lord. What I-
They filed an application to vacate a stay. We'll either allow it or we'll dismiss it. But we can't say you wait for 6 months, 6 weeks.
No, I'm not asking that. I'm not saying that, my lord. All I'm saying
You
is,
after view is 6 weeks.
well, but what do we do, my lord? There are vacations coming in between, my lord. Otherwise, we are ready. But the point is this, my lord.
Yes.
My lord, it's a detailed application for vacation of the stay of an order passed in December, appeal dismissed on 19th February on the same facts. All I am saying is give me an adequate opportunity to file a reply. Your lordships will list the application for hearing. That's my humble request, man. Nothing else, my lord.
The IA.
Yes, my lords. In the IA, I'm just seeking, my lord, adequate time to file my reply so that we can argue on the IA.
All right. We'll fix it on 7th. You file your reply.
So grateful.
Heard Mr. N. Kohli, Learned Senior Counsel, appearing for the applicants stroke state of Assam. This IA has been filed with a prayer to vacate the order date. What is the date of the order?
Lordship, in the first matter, it is 6th of December 2024 and 10th of January 25.
2024, as well as the subsequent order dated 10/1/2025, passed by the learned single judge in WPC number 5862 of 2024. Mr. A. Chaudhary, learned senior counsel, appearing for the writ petitioner stroke opposite party, submits that this being a voluminous application, a reasonable time be granted to him to prepare and file a counter affidavit. Full stop. The prayer is found to be reasonable and therefore is hereby allowed. However, on the request of Mr. Kohli, learned senior counsel for the applicants, expressing urgency in the matter and also informing this court that similar writ petitions are fixed before this court on 7/4/2025. This IA, along with the connected proceeding, is also directed to be posted on 7/4/2025 for orders. In the meantime, the writ petitioner opposite party may file objection in the IA if so advised. The writ petition will see it later. Right now, we are only concerned with the IA.
Very well. Very well.
We'll either dispose of the IA this or that way, and the writ petition will go on its own merit. Yes, anything?
I'm grateful, Lordship. Just for the record, Lordship, there are different orders in the different 16 and 17, but broadly they are the same period. November to January.
I'm not aware. I have not gone through the
Yes, of
report.
course. I can give those dates. If
At the
Lordship.
moment, the only thing is the state wants an order to be vacated. This matter has to be looked into.
I'm grateful.
Reasonable time is given to the other side. We'll look into it and then see what steps are to be taken. I'll request both of you to consider physical appearance in the matter.
Not Lordship, we are assuring you physical appearance.
Because I don't know, I'm finding it very difficult. And could you, the learned members of the bar, these matters can't be heard like this.
No, Lordship. That's why we requested the date when Lordship has.
Noise,
Full
cacophony.
Lordship has kept it on 7th.
Yeah. Mr. Chaudhary,
Very well, my lords.
anything else you want to say?
That's all, my lord. I wanted to file an affidavit in reply to the affidavit in opposition.
You
Give me
file
4
it
weeks
by all
time.
means. You
So
file it
writ,
by all means.
in the writ, my lords, I may be given 4 weeks time to file my affidavit and reply.
All right, writ petition will give him, how much time you want, Mr. Chaudhary?
4 weeks, my lords.
All right. Which is your writ petition?
This is with item 15, my lord, WPC 5862 of 2024.
You write in WPC, you write 5862 of 2024.
And 6191 of 2024.
And WPC number 6191 of 2024. Heard Mr. A. Chaudhary, learned senior counsel, assisted by Ms. B. Chaudhary, learned counsel for the petition in both these petitions. Also heard Mr. N. Kohli, learned senior counsel, assisted by Mr. C.K.S. Boro.
And Lordship, if I may also request Mr. A. Roy and Miss N. Menon.
Sorry, can you?
A. Roy, Mr. A. Roy and Miss N. Menon.
Assisted by Mr.
A. Roy and Miss N. Menon. Nimisha Menon. N. Menon.
Yes, Boro. learned counsel appearing for the respondents in these cases. On the request of Mr. Chaudhary, learned senior counsel for the petitioners, 4 weeks time is granted for filing rejoinder. You want to file rejoinder, is it?
Rejoinder.
Yes,
Mr. Chaudhary, you want to
yes,
file?
yes. Rejoinder, my lord. What your lordship say, affidavit in reply.
Uh, let the matters be listed accordingly. Yes.
I'm grateful.
Lordship, item 15, 16, 17, similar orders, Lordship.
Yes, yes.
Grateful. I'm so grateful.
Lord, so far, item 17 is done.
Yes.
I am appealing on this matter. Lord, I have small submission. Lord, this matter, the ground of challenge is not identical to item 15 or 16. In item 15 or 16, my lord, the petitioners have challenged the commission of inquiry, the report of the one-man commission. Here, my lord, item 17, my lord, similar to other matters wherein we have challenged purely on the basis of simultaneous proceeding. I don't know, my lord, how this got tagged into it, but the issues are totally different. Main issue is same, but the ground of challenge are different, my lord. Perhaps this has to be detected, subject to what your lord.
Pass it on accordingly.
Yes.
Item 17 of Likho, Mr. HK. Is that correct, Mr. Kohli? Will you
Lordship, there is a slight difference. That is correct. It is broadly similar. Our arguments are almost identical. That's why I use that word. I would, Lordship, say that it could be kept on the same day, even if he wishes to detag it. We can argue that separately because there will be very minor difference.
Right.
And therefore, I'm requesting for keeping them together on the same day, Lordship.
I heard Mr. HK Das, my counsel for the writ petition, item 17, who submit that the issues involved in this writ petition are slightly different from the other matters, and therefore there is no necessity to hear all these writ petitions analogously. Full stop. Mr. N. Kohli, learned senior counsel appearing for the respondents state, submits that there could be slight difference as regards the crucial issues are concerned. However, the matters be posted on the same day. In view of the above, register to detect item 17 from item 15 and 16 and list the matter again in the appropriate column on 7/4/2025. Yes.
Fine. No problem.
Grateful. So deeply obliged.
Lord, the interim order passed. That
Interim order passed earlier to continue till then.
highly obliged.
Grateful.
Item 18.
Yes.
Order no steps.
Your Lordship. Lordship, office note says that, Lordship, office note shows that steps were not taken, Your Lordship. 3 days time may be given, Your Lordship.
On the request of Mr. T. Chetri, learned counsel for the writ petitioner, 3 days time as last opportunity is granted to the petitioner to take steps, failing which consequential orders would be passed. Ms. M.D. Bora, learned counsel for the respondents.
One, Lordship, cooperation.
One is present.
Much obliged.
Supplementary list, item 54 and 55. Order impeachment of party.
May I please, Your Lordship? My lord, this prayer for implement of the PNRD department in the writ petition and also the connected IA.
Yes, you want to implead whom?
I want to implead the principal secretary PNRD and commissioner PNRD as necessary parties in writ petition 2869.
You withdraw and file again. You made the same mistake. Few days back also you made. You have already implemented them.
No, my lord, I have
respondents.
implemented them in the IA. But now I want to order from this honorable court to implement them as respondents in the writ petition. In the instant IA, I have implemented them as parties.
But that's all right. You want to implead whom? Opposite party numbers?
14 and 15 of the instant IA as respondent numbers 14 and
They are the only opposite parties in the IA. Others are not opposite parties in the IA. They are the respondents in the writ petition.
My lord.
You have to rectify it. It is causing problem in our system. You made the same mistake and you withdraw the petition to file again. It happened, I think,
Yes, last.
10 days back. Then why have you made the same mistake now? You want to withdraw or I can close it?
Can the matter be taken up tomorrow? My senior will address the honorable court.
No, the senior has nothing to do with this.
My lord,
You have to give the name of the opposite party.
my lord.
Your petitioner here is one Mr.
Petitioner is Mr. Kaushik Das.
Kaushik Das. And the opposite parties are principal secretary and commissioner.
Yes.
Why have you made them number 14 and 15? They are the main opposite parties in your IA.
Yes, my lord.
They will be, if they are implicated, they will be respondent numbers 14 and 15.
Yes,
Why
my
have you made them 14 and 15?
My lord, I explained it to my senior. This is what instructions.
Who is your senior?
Mr. F. Khan.
Let him come. We'll see. On the prayer of counsel for the applicant, these matters are directed to be listed again day after tomorrow.
My lord. Obliged, my lord.
For admission, item 9. Item 19.
None appears for the writ petitioner on call, Mr. P. Nayak, and Standing Counsel Finance.
Yes.
And Mr. D. Voral and a government advocate Assam are present. Since the petitioner's counsel is absent today, this matter will be listed again after the bill vacating.
Item 20.
My lord, can we take it after something? Senior Counsel, Mr. Saibal, I don't know.
What is the matter, Mr.?
Better regarding lordship, I have been deprived from the pay band which I am entitled. The pay band lordship after promotion, which I am entitled to lordship, from that I have been deprived. And there is a second prayer also, that my designation is wrongly put, but that part I am waiving right now lordship as because I have resigned from that department and joined in another department. But this monetary benefit lordship, because of my discontinuation of service, this monetary benefit, that part is still there lordship.
So they have filed affidavit.
File affidavit, I have filed the reply. It will take time lordship, 15-20 minutes time, I think.
Then why don't we fix it on a non-miscellaneous day?
Lordship.
Is there any urgency? We can have it after due.
Urgency, no lordship, there is no such urgency, but even then lordship is pending for 2018.
All right, heard Mr. H. Sharma and a counsel.
Any hearing there lordship?
Yes. Also heard Mr.
HK Sharma.
H.K. Sharma and
Respondent number 5.
Ms. A. Gahan.
Respondent number 1.
Respond number 1.
One, only one, yes.
What about 2, 3, and 4? Down to 1 and down to 5. None is appeared for the respond numbers 2, 3, and 4.
My whole grievance is against the Tea Research Association lordship. ERA.
Keyboard to the Ministry of Commerce. Council. Keyboard. So council is.
The Tea Research Association, why respond number 3, 2, 3, they are not served? Respond number 4. And what about 6?
Lordship, I'm sorry, lordship, I have not gone through lordship. Respondent number 5, lordship, they have filed their affidavit.
No, I am asking, is service of
Lordship,
notice
lordship,
complete on the other respondents?
Lordship. I am sorry, lordship, I have not.
No, just 1 minute. Mr. Sharma, just have a look. It seems there is nothing about service of notice on respond numbers 2, 3, and 4.
Lordship,
Just have a look. Both of you, just have a look.
Item 22.
Lordship, the finance department and judicial department were supposed to file their responses as per order dated 29/11/2024.
Fees were Lordship, here some time may be granted to the finance department, Lordship, because we apparently had rejected it on the basis of how the bill has been submitted, Lordship. Some time may be granted. We were impleted.
What is this matter about?
The petitioner is a counsel representing the social welfare department. She's claiming her unpaid professional fees. Unpaid professional fees and expenses.
Professional fees.
Lordship.
What is the amount involved?
Now the amount which remains pending is around 1,40,000.
1,40,000.
Yes, Lordship.
So,
Lordship, here.
Harassing people for 1,40,000.
No, Lordship, here, as per, I do not have the proper instruction, Lordship, there the manner in which the bill, some amount has been paid, but the manner in which the bill has been raised, there was some dispute regarding that. Some payment has been made.
These are not contractual bill.
Yes, Lordship.
Is some amount. What is the problem here?
Here, Lordship.
Denying this amount is due or disputing
Lordship,
it?
as per the available, what has the allotment per case, the amount is supposed to be paid per case and not as per the number of representatives in the contempt case. That is the main dispute, because of which in one case, if the amount is per case is supposed to be paid 20,000, Lordship. If now the problem is if there are 5 contemners, if the petitioner is appearing in for all 5, so now the amount has become 20 into 5. That is the dispute, Lordship.
You don't have any SOP, any guideline?
Lordship, as here, as per the government affidavit, as per the SOP, it's supposed to be paid one case, Lordship. Not all the.
What the Honorable Court wanted to know on the last occasion after deliberation.
No, first respond to what he's saying.
Yes, that the trend which is being.
So he is saying that in a case where there are 5 respondents,
Lordship.
the bill has been multiplied by 5.
In fact, Your Lordship, what happens is in a contempt proceeding, there may be an occasion where different advocates may represent all the respondents, or one single advocate may represent all of them. So what is happening is the trend is that when one advocate represents all the multiple respondents, he is paid separately for all of them, because contempt proceedings are separately initiated against all of them. Though all of them may be impleaded together in the same.
What is the basis of this submission?
Their submission, they are referring to a notification of the finance department saying that it is per case. But what the Honorable Court wanted.
Here, this dispute, unless it is resolved, how can there be a
Just let them file their affidavit. Very good.
That is the case, Lordship.
That whether they are following it as a per case basis or on the number of respondents. That is all.
Then let them file their. You want to file?
Yes, Lord, let us get the instruction, because we were impleted, Lordship.
Yes,
this
they
is
were
on the
impleted
basis of the judicial department. I am making the statement, Lordship.
They were impleted later on 29/11.
After finance department rejected. So.
You are appearing for the newly impleted respondent number 6 and 7.
6, Lordship.
All right. He wants time. How much time he wants?
Lordship, 4 weeks time may be granted, Lordship.
Very well.
Had Mr. KP Pathak, learned counsel, appearing for the writ petitioner. Also had Mr. H. Solia, learned counsel, appearing for the newly impleted respondent number 6, who prays for 4 weeks further time to obtain instruction and file affidavit. Mr. S.S. Roy, learned G. Assam, appearing for the respondent numbers 1, 2, and 3. And Mr. Sniv, standing counsel for the Office of Accountant General, A&E Assam, are also present. Mr. C.K.S. Borwa and G. Assam is present on behalf of the respondent number 7. On the request of Mr. Cholia, this matter is adjourned for 4 weeks so as to enable him to obtain instruction and file affidavit. List accordingly.
Item 20, Lordship.
Yes.
That order is there, Lordship.
Yes.
My
I'm
learned friend
taking-
accepts notice for all, Lords.
Initially, I accepted notice for all the respondent, but after during the proceeding, court number respondent number 5, they have appeared. No? They have appeared for respondent number 5, and I am appearing for all the remaining respondents.
So you have
Notice is
instructions.
complete, Lord.
Notice
1 to 4 and 6 you are appearing.
Yes, my lord. So, my lord, I may be allowed to file affidavit in opposition, within 4 weeks,
See, now it has taken a different turn.
Yes, ma'am.
You are not aware who is your client,
No,
is it?
well, I am aware that during the proceeding, madam, they appeared for respondent number 5, madam. I thought they will appear for all the remaining respondent and that.
They have proved you wrong.
Yes, ma'am.
Let her file, we'll fix it. In the
Lordship.
month
Yes,
of
ma'am.
May, we'll
Yes,
fix it. But Mr. H. Sharma and counsel appearing for the writ petitioner also.
In the meantime, let them file lordship,
Yes,
that may
fine.
be fixed. Lordship.
And counsel appearing for respondent numbers 1 to 4 and 6 who submits that 4 weeks time be granted to file affidavit. Mr. H. K. Sharma and counsel is present on behalf of respondent number 5 and submits that the counter affidavit on behalf of his client has already been filed. Be that as it may, in view of the nature of grievance expressed in this writ petition, this matter would call for detailed hearing. As such, admit the writ petition. Since the respondents are already represented, no formal hearing is called for in this case. Let this writ petition be listed again on 20th of May 2025 as a fixed item for hearing. The respondent numbers 1 to 4 and 6 may file counter affidavit on or before 5th of May 2025 if so advised. Yes.
May I pray, Lordship, let it be in the admission column, Lordship. In that case, the matter will come in the part 1 list, Lord.
But per admission, chances of hearing is less. Like
That is true, Lordship.
fixed item hearing, more chances.
Lordship.
Yes.
Much obliged.
Lordship, in this matter, we have our previous we sent it for vetting. Let the matter be taken up next week, Lordship. We have already sent it for vetting.
I don't have any objection to this. But matter relating to Millard, what happened? We have one was farm. We were doing fishing addition. That in the meantime, what happened in our Mariposa land? Then when we are doing one PI was filed before this honorable court, that land is required for bird sanctuary. This our honorable PI disposed of. That you take, forest department was directed to take decision. They did not take decision. And the day after, suddenly they have given us requisition to our land. Our state as on date, my lord, if you want land for forest, then you pay us the compensation according to provision of law. Or if you do not want to go for that, you give us the land. That is our Mariposa land, my lord. That is our issue. That's why
This is a bench 5 matter. Huh?
It's a bench five.
Bench 5.
Anyhow, Miller, as is praying next week, Miller, you'll file.
But this is 21 matter. Anyway, we'll. just
He's
point
praying
out-
1 week time, Miller. Later.
No, 1 week is not possible, Mr.
He's
Bhopal.
only praying, Miller.
We'll adjourn it for 2 weeks at least.
He's only praying.
He's only praying, but we can't- because every week we can't circulate these cases like
10
this.
days, 10 days.
And
Because
in
it's
that
the old
case,
cases, Miller.
Only 200 cases will be listed. No other
That's
case.
correct, Miller. If affidavit is only very simple affidavit, simple, our submission will be very limited and decision will be limited.
All right, I heard Mr. C. Borwal and counsel appearing for the writ petition has also heard Mr. R. Gogol. and
Sending council forest, Lordship.
Sending counsel Forest Department Assam who prays for 7 days further time to bring the affidavit on record. Mr. H. Sharma, and you are appearing as?
From the state government.
And counsel for the state of Assam is present. On the request of Mr. Gogol, this matter stands at for 10 days so as to enable him to
Right.
file the counter.
Obliged.
For both the cases, Miller. Obliged.
23, 25 both matters.
May it please your Lordship. In this matter, Lordship, a part portion of the prayer has been already granted. All the petitioners have undergone the pre-promotion cadre training. Some of them have been now promoted also. Their posts have been confirmed. Now 7 of the petitioners, their posts are still not confirmed. Now I have come to know that some DPs are pending, departmental proceedings, as well as some criminal cases, some anti-corruption cases against these particular petitioners. Now the fact is that on last occasion, on the last date of hearing, the respondent authorities were sought instructions and they were supposed to reply on since notice was issued. Now, in this particular matter, now nothing much remains actually. The fact is that we were actually challenging the selected list of those confirmed SIs whose name were,
Nothing much remains, you close it with liberty to.
yes, that will be the much more righter direction.
I heard Mr. W.R. Mehdi, learned counsel for the writ petitioners, also heard Mr. C.K.S. Borwa, learned G. Assam, appearing for the reference numbers 1 to 6. Mr. Mehdi submitted that during the pendency of this writ petition, the grievance of the 12 writ petitioners have been substantially redressed, and therefore, on the original prayer, nothing further survives for adjudication in the writ petition. Mr. Mehdi has, however, submitted that some of the writ petitioners may have individual cause of action to file separate proceeding in the light of the departmental proceedings allegedly drawn against them. Therefore, granting liberty to such petitioners to avail appropriate legal remedy in the matter as may be permissible, Mr. Mehdi submits that the writ petition may be closed. The prayer is not opposed by Mr. C.K.S. Borwa and G. Assam. In view of the above, the writ petition stands closed with liberty as prayed for.
And one more, Your Lordship, writ petitioner 1, he has passed away.
All right.
Yes, it will be like.
Second line nobody over. Mr. Mehdi further submits that the writ petitioner number 1 has passed away during the pendency of this proceeding. If the grievance has been redressed, then this line.
Obliged, Your Lordship.
Thank you, Your Lordship.
Yes.
The petitioner was suspended for unauthorized absence without considering her medical applications on medical ground. And now she was reinstated and she was imposed a penalty of censure. But she is earned leave of 214 days and her medical applications were not considered. The lady has some gynae problem. She has gynae problem. So all my prayer is has been reinstated. Only there is a prayer left for recovery of arrear salary. I filed the additional affidavit. Even the inquiry officer has said to join the place of posting and go for medical leave. In the report of the inquiry officer. The report of the inquiry officer is page 263.
This is Finance Department.
Yes.
Who is appearing for the Finance Department?
On the last occasion, A. Solia was.
Kindly pass over for the timing eyes.
Time being.
27.
Lordship, item 27, I need some more accommodation to finalize, Lordship, next week, Lordship.
You want accommodation to file affidavit?
Lordship, they are trying to settle the matter, Lordship, so.
So who is for the petitioner here?
Matter has been listed by order. Padgri.
What is the matter? What is the issue?
Issue is, Lordship, the date of birth, Lordship, joining and qualifying service of the master worker, Lordship.
Basically,
Need some more time. We'll put it after Bihu.
Lordship.
None appears for the writ petitioner when the matter is called up. Ms. R.B. Bora, Lana Standing Council, BTC submits that the matter is being deeply examined by the authorities and therefore another 3 weeks time be granted for taking a decision on the grievance of the petitioner. Mr. N. Upadhyay.
I am for 1 and 4, Lordship.
Standing Council, Irrigation Department and Mr. D. Bora, Learned G. Assam are present on behalf of the. C. Bora are present on behalf of their respective councils. On the request of SC BTC, this matter is directed to be listed again after the upcoming Bihu holidays.
Obliged, Lord.
Deeply obliged.
Item 28.
Lordship, I have submitted a prayer for correction in the serial number of the paragraphs. There is a slight mistake. I apologize for that. In original petition,
In page number 13, after paragraph 25, it should have been 26 onwards, but by mistake, because of some computer setting, it has been restarted again from 60. And taking advantage of this mistake, the other party has already filed their affidavit, but they have not replied to any of the issues that I have raised from those paragraphs. So I pray before your lordship to kindly allow this correction so that the paragraphs can be correctly numbered.
How you want to make the correction?
In that original petition, only the paragraph number.
How you want to make the correction? How?
I have already submitted an IA.
IA.
Yes.
So if it is permitted, then you have to file a fresh writ petition. That's the problem, because we have everything, all data is in the system. Every petition has to be there in the CIS system. If there is a mistake in para numbering, then
I have no objection.
You have no objection. We'll allow it, but what is the matter about?
Matter is about, actually, lordship, I was denied promotion on the basis of uncommunicated APR. So I had originally filed a writ petition before this honorable court. So the court had passed certain directions for review of my case. And a clear instruction was given how that objective review has to be done and what are the essential elements of an objective review. But despite such a clear instruction, they have again repeated 2 times I went to them. But on both the occasions, they have done the review, but not complying the instructions of the court. So this writ petition I have again submitted.
And you are serving, you are working.
I have already retired, lordship.
You already retired.
Yes, lordship.
You retired as what?
Retired as chief manager.
Of?
From Punjab National Bank.
Okay. So what is the relief that can be granted to you now?
Relief, lordship, if my APR is upgraded, I have given the grounds. If my APR is upgraded, in that case, I'll be eligible for all consequential benefits. There are case laws also. I can quote, lordship.
All right, first we'll see the IA. Let us see. You are Mr. Debashish Roy.
Debashish Roy.
So Debashish Roy, the petitioner stroke applicant is present in person. Mr. S. Dattal and his senior counsel listed by Ms. S. Musari. Learned counsel is present for the opposite parties stroke respondents. Full stop. By filing this IA, the applicant lead petitioner is seeking leave of this court to correct certain typographical mistakes in the writ petition, whereby the paragraphs have been incorrectly numbered. Full stop. Mr. Roy submits that taking advantage of such typographical error in the writ petition, the respondents have not responded to the key averments made in the writ petition, thus causing serious prejudice to his interest. Full stop. Mr. S. Dattal and his senior counsel for the opposite party submits that he would have no objection if the prayer is allowed. In view of the above and taking note of the grounds stated in the IA, the prayer for rectification of the typographical errors are hereby allowed. The petitioner is granted 2 weeks' time to file a writ petition by rectifying the fresh file copy of a writ petition by incorporating the corrections as prayed for in this IA. After filing of such writ petition, it will be open for the respondents to file additional counter affidavit within next 3 weeks, if so advised. Let the matter be listed accordingly. IA stands disposed of.
Blessed.
You give them a copy, they'll file a fresh affidavit. Yes.
May it please, my lord.
May it please,
I
my lord.
appear for the respondent in this case, my lord.
Yes.
My lord had already directed that a medical board be constituted as per my lord's order. My lords will kindly see my lord's order of 15th of October, sorry, 28th of November 2024, my lord. 28th November. So a medical board was to be constituted. It was duly constituted, my lord, and it has been found that he is deficient in height. The report, my lords, has been filed also by the superintendent of the Guwahati Medical College, my lord.
Where is the report?
The report is at page 98.
98, my lord. 97. The affidavit, my lord, starts subject to correction at page 93, my lord. Subject to correction.
So, Mr. Fukan, you
Lordship,
have seen
in
the
this,
report?
I've seen this report, my lord, and before the my lord report was, I would like to submit, my lord, before the report was, my lord, the seal cover was opened, my lord. If your lordship sees order dated 17/2, my lord, 17/2, my lord, I had before the report was opened, I had made a my lord submission, and the honorable court had directed, my lord, me to file an affidavit in opposition, additional affidavit, my lord, wherein, my lord, bringing on record, there were three, my lord, regarding the height only, my lord. The height, my lord, the stadiometer on which they had taken the height measured, my lord, three measurements were taken. So we were, my lord, we had told them that, my lord, it should be taken only once, like how the eyesight they have taken only once. The stadiometer meter malfunctioned, my lord. So therefore, my lord, I was asked to, my lord, I have accordingly filed an additional affidavit. But, my lord, that anxiety is there of the petitioner, my lord.
No, Mr. Fukan, I'll close the matter now. I'll only tell you why.
My lord.
You came to the court with a grievance that they have wrongly ousted you from the.
Initially,
yes, because the parameters were wrongly identified.
My lord.
You are not deficient.
My lord.
Taking note of your argument, the court appointed a special committee. They have gone through it, given a report according to which you are deficient.
My lord.
You have to accept it. These things can't go on like this. Matter ends here. You prefer an appeal against this order if you want. We can't prolong these things like this. We wanted to ensure that nobody feels his grievance has not been looked into by a fair and transparent process. It has been done. You are not alleging malafide against the doctors. You can go on filing affidavits for next 20 years as long as the interim order is there. We can't permit this. This is not the
I leave it
purpose.
to your lordship.
We'll close the matter.
My lord.
Yes. Heard Mr. A. Fukan, learned counsel appearing for the writ petitioner. Also heard Mr. C. Sharma, learned senior counsel assisted by Mr. D. Decker, learned counsel appearing for the respondents. The writ petitioner hearing had submitted his candidature for recruitment to the post of junior assistants in terms of the advertisement notice dated 30/12/2023. However, on conclusion of the selection process, the petitioner was not recruited on the grounds that he did not meet the height and the eyesight requirements as per the advertisement notice. Situated thus, the petitioner has approached this court by filing the present writ petition, inter alia contending that the respondents have committed an error in assessing, in measuring and assessing his height as well as eyesight, thus wrongfully ousting him from the realm of the selection process. First up, taking note of the petitioner's grievance, and in order to ensure that the candidature of the petitioner, insofar as his physical standards is concerned, is evaluated through a fair and transparent process, this court, wide order dated 28/11/2024, had directed the superintendent of the GMCH to constitute a special medical team of competent doctors so as to carry out the measurement of height and eyesight of the petitioner. Accordingly, a team of doctors, medical team of competent doctors was constituted who had examined the height and eyesight of the petitioner. From the report dated 5/12/2024, submitted by the aforesaid team, it appears that the petitioner is in fact deficient in his height as well as eyesight.
Lordship, eyesight is fine, only the height.
Deficient in terms of his height vis-a-vis the parameters laid down in the advertisement notice. If that be so, there cannot be any dispute about the fact that the writ petitioner did not fulfill the eligibility criteria as laid down in the advertisement notice. If that be so, it cannot be said that the petitioner has been wrongfully denied of appointment in the post of junior assistants. Consequently, this writ petition is held to be devoid of any merit. The same is accordingly dismissed. Is there an IA here? All right. All right, next matter.
May I please, your lordship? No, this is suspension matter. Now, lordship, more than 1 year has passed, no review order has been passed. They have filed an affidavit, lordship, without annexing any order, lordship, saying that their review has been done. But in one paragraph, lordship, they have categorically stated the review was done. If your lordship kindly come to affidavit in paragraph 11, they are trying to say that review was done. In fact, no order was passed and no order was communicated to the petitioner as well. But it more than 1 year, lordship, I was placed under suspension, lordship, with effect from 11/12/2023.
What has happened? Some DP has been initiated.
Yes, Lordship, it is, DP is already over, Lordship. Now, as per new procedure, Lordship, this has been sent to the Revenue and DM Department, Lordship, to take the final call. And the last order of suspension was reviewed on 10 December 24, Lordship.
Who is there? That order has not been annexed.
And he is getting the subsistence allowance at the rate of 75%, Lordship. And this has been regularly paid, Lordship.
Well, not within, lordship, 3 months, no review order was.
That will hear it.
And
in
their
due
type
course.
of, their type of, lordship, they are trying to say that it was some date, lordship, the review was done. Well,
No,
that has
but
not been.
They
annexed.
filed affidavit.
Yes,
Already
everything
filed, Lordship,
filed.
but that document was not there. We can file an additional affidavit in that regard, Lordship.
Their order
Lordship,
was also not communicated to the petitioner, lordship.
We'll see, let them file the additional affidavit.
Lordship, I shall.
What is the charge? Corruption?
My
Yes,
lord,
lordship.
some bribery.
Bribery charge, Lordship.
Mr. M. Khan, learned counsel for the petitioner, also heard Ms. N. Bhattacharjee, learned additional senior government advocate, Assam, who submits that the departmental proceeding submits that the order of suspension of the petitioner was last reviewed on 10/12/2024, and thereafter the same was extended. It is the further submission of Ms. Bhattacharjee that the departmental proceeding drawn up against the petitioner has since been concluded, and the matter is pending final decision of the disciplinary authority. The learned state council therefore prays for 2 weeks' time to file an additional affidavit, bringing the subsequent developments on record. Prayer allowed. Let this matter be listed again after 3 weeks or immediately
Date
after.
may be given, lordship. And bring any date, lordship, fixed date, lordship.
Fixed date will be after BU then. In the first week of May, it will go. Let them file it. It will be. This is a better order for you. 3 weeks or immediately after filing the counter additional affidavit, whichever is earlier.
Deeply obliged.
Please, Your Lordship. Your Lordship, in this matter, Your Lordship, the petitioner has challenged the impugned suspension order, Your Lordship, which was issued on 2/5/2024 with effect from 8/3/2024, Your Lordship. On the last occasion, Your Lordship, the state respondents were directed whether any review was done within the period of 1 month, Your Lordship.
My lord, as per our information, 2 reviews took place. One 29/10/2024, another 27/1/2025, Lordship.
Yes. So you can give him the copies. You give him the copies and you want to file, you want to obtain instruction, you obtain.
Your Lordship, the petitioner was suspended on 8/3/2024 by an order dated 2/5/2024, Your Lordship. Show cause notice was issued on 19/9/2024, Your Lordship, and the review had, as placed by the learned counsel, took place, Your Lordship, after a lapse of 90 days, Your Lordship, 29/10/2024.
So therefore, you bring this on record, make your submission. They are not filing affidavit. We have to pass a judgment on this.
Yes, Your Lordship.
Bring your.
Yes, sir.
You are saying that since 90 days has passed, subsequent review will not be of any consequence.
Yes, sir.
That may be correct, but you file the pleadings.
Yes,
How
sir.
much time you want?
Your Lordship, 2 weeks' time, Your Lordship.
2 weeks' time. Okay. Mr. D.S. Dekal and counsel for the petitioner submits that The order of suspension dated 8/3/2024 issued to the petitioner was not reviewed within the period of 90 days, and therefore the same has already lost its validity. Mr. I. Bhattakur, learned standing counsel for the Forest Department, on the other hand, submits that the suspension order of the petitioner was reviewed twice, that is, once on 29/10/2024 and thereafter again on 27/1/2025. From the above submission of Mr. Bhattakur, it is clear that the order of suspension was not reviewed within 90 days from the date of issuance of the same. However, since these are subsequent developments, on the request of Mr. Decker, 2 weeks' time is granted to file an additional affidavit, bringing such facts on record, so as to enable this court to pass appropriate orders. You want this, you can take this, give him a copy, list accordingly.
Much obliged, Your Lordship.
Yes.
I'm being admitted.
Yeah, I've got the instructions, my lord. I pray for 10 days time to file my affidavit. Finance taxation. Even then, my lord, I'll file it, my lord.
Only for area consideration.
So let him,
Lordship, in 10 days I will file.
it seems the inquiry officer himself advised her to go for leave after joining.
Yes, I have annexed.
But
Have you
let
seen
me
this?
file my affidavit, yes.
Show it to him, show it.
263.
Page 263.
Revenue is 268.
My lord.
Let him file. Had Mr. S. R. Gogol and counsel for the writ petition, also had Mr. B. Gogol and standing counsel, Health and Family Welfare Department, Assam, who prays for 2 weeks further time as last opportunity to file affidavit. Prayer allowed as last opportunity, let the matter be listed accordingly. Yes, sir.
Obliged.
My lord, I'm appearing on behalf of Mr. M. Chanda for the petitioner. My lord, 3 more days may be granted to take steps upon the respondent number 1, 2, and 3.
Your name, please.
S. Goswami.
On the request of Miss S. Goswami, learned counsel appearing for the writ petitioner, 3 days further time is granted to the petitioner to take fresh steps for service of notice upon the respondent number 1, 2, and 3, failing which consequential orders will follow.
Much obliged.
List accordingly.
I'm 36.
Please, your lordship. In this case, lordship, I was directed on the last occasion. I was asked to directed to take the steps on the respondent number, sole container number.
Yes.
Container. So accordingly, I tried my level best to get the information to the petitioner. So the petitioner has not getting a response from the petitioner side. That's because who has engaged me in this case, who my lawyer of Guwahati. Even then, I also asked her to get the information. I'm failed right now. Now it is up to your lordship what to do, lordship. I'm unable to get the information regarding.
No, notice on whom? Which respondent?
Respondent number 1, so Dr. Sudip Juti Das. During that time, the Joint Director, Health Service, Kasar. And one Roshin Bhuya, Director, they both of parents both were retired now. It's a long pending matter.
Both have retired.
Both have retired, I think. Director Roshin Bhuya is retired now, that I confirm. But regarding Dr. Sudip Juti Das, Joint Director, I have no idea.
It's a non-payment of salary of 2 months. It is approximately 59,000, 6,000 around. It is your lordship's order itself, page 9 of the content.
Where is the order?
Order is page 9 of the content petition. Order 9 is your lordship's order.
Can anybody just call Mr. B. Gogoi? We'll find out whether these two respondents are still working. And if not, who are the officers in their place? Just wait for 10 minutes. Huh? We'll call B. Gogoi.
37.
None appears for the petitioner on call. The petitioner's counsel was absent even on the previous occasion when the matter was, even on 2 previous occasions when the matter was listed before this court. In view of the above, it is apparent that the petitioner is no longer interested to pursue the matter before this court. Full stop. This contempt case is therefore closed.
And 36.
Mr. Gogoi. You see, this is a contempt matter, but it seems there was a direction to pay some arrears salary. And now what the court wants is, can you please find out if these 2 persons are still in office?
Yes, sir.
And if not, who are the officers in their place? We'll have it on Friday. You just find out this much. Rest will go by as per. And then this is a small issue, 2 months salary. Next Monday?
Monday.
Mr. T. Boydal, learned counsel, is present for the petitioner. This matter is directed to be listed again on next Monday, date to be as a fixed item. By showing the name of Mr. B. Gogoi, learned standing counsel, Health Department, Assam, in the cause list.
Item 38.
I plead the lordship. Since last 2-3 occasions, they are not appearing.
Right. None appears for the petitioner on call. The petitioner's counsel was absent even on the previous occasion when the matter was listed before this court. It appears from the Loajima Court order dated 12/8/2024 that the petitioner has also failed to take steps for service of notice upon respondent number 4, despite the order passed by the court. First of Miss
As Dev, lordship.
S.
Dev.
Dev.
Yes, sir.
And that counsel is present for the
Respondent number 2 and 3.
respondent numbers 2 and 3. It appears that the petitioner is no longer interested to pursue the matter before this court. The writ petition therefore stands dismissed for non-prosecution.
Obliged, lordship.
Item 39.
Your lordship. Step have been taken on the newly implemented respondent number 2 on 21/6/2024, your lordship. Were registered as well as
But the office note says amended cost title for newly.
yes, amended cost title has been filed as per order dated 14/6. Then we take step on 21/6.
Extra order dated
14/6/2024.
No, but
Implement allowed.
Listen, Mr. Marunga, listen. Office note said you have not filed it. So point it out where you have filed it. Otherwise, you have to file it. Take it. Give it to him.
Implement order 14/6.
You have not filed amended cost title.
Amended cost title has already been filed, your lordship.
Check it out. Point it out where it is. Yes, next matter you call.
Item 40.
May please, your lordship.
My lord, it is a contempt application alleging violation of the court's order dated 16/12/22, asking the respondent, my lord, to release the arrears salary and gratuity. Now, after a period of 2 years, my lord, they have made certain calculations. They have filed an affidavit, my lord, and a table has been annexed, my lord, indicating the arrears salary, my lord, and gratuity. But, my lord, this is a decision of 2000, November 24, but till date, my lord, the amount has not been released, my lord.
No, Lordship, the original order was to take a decision whether the petitioner is entitled for the salary or the gratuity, Lordship. That decision has been taken, Lordship. Lordship, may you kindly peruse the page 10 of the petition, Lordship.
So you have to pass a reason order. Have you passed that order?
Lordship, order probably by this time it has been passed. The order, the affidavit has been filed on 10/1/2025, Lordship. So let me take the instruction, Lordship.
My lord, my submission is, the argument is that there was a direction only for taking a decision for calculation. Now they take a decision, they calculate the amount, now they do not release. So can we understand the order, my lord, of the honorable court in that manner? You take a decision and you withhold the amount. They are not releasing the amount. My lord, 1 week back, my lord, when he visited the respondent, my lord, she said, we have filed contempt, we will not pay. My lord, this is the conduct of the respondent too. And my lord, making a statement on bar, my lord, with all responsibility.
No, Lordship, that is not the case. On 7/3/2025, the petitioner visited the office of the restaurant number 2, Lordship. So, his behavior was very rude to the said respondent and the other officers of the respondent also. A police case has been filed against the present petitioner also, Lordship. The decision has been taken. Restaurant number 2 is
Chief
the
executive officer, my lord.
Executive officer, Lordship. So let me take the instruction, Lordship, whether the order has been.
You can't harass people like this.
No, Lordship, the thing is that I have been told there is a it is the municipal board is running out of its own source, Lordship. There is a financial trans also on the part of the municipal board. So the statement has been prepared, it has been annexed and it has been filed with the affidavit, Lordship. It will be released, Lordship. So let me take the instruction whether. Yes, Lordship. Lordship, I'll take the instruction. If necessary, I'll file another affidavit, Lordship.
No. Your time is very limited now.
Lordship.
On Monday.
But there is the huge implication of rupees. If we go by the calculation also, Lordship, it's a rupees 15 lakhs rupees altogether. At the time, the municipal board is unable to pay, Lordship. It is the difficulty, Lordship. So far, I have been instructed, Lordship.
Then you have to ask for modification of the court order.
But
in any case, you have to communicate the decision.
Lordship,
When
probably by this time it has been communicated. Order has been so far I have been told. So let me take the instruction. Lordship may take the matter on Monday, Lordship.
Let's see.
My lord, Lordship will make some observation, my lord.
Mr. S.K. Talabia Learned Counsel is present for the petitioner and submits that despite the categorical order of this court, the respondents have not communicated their decision in the matter, let alone releasing any amount in his favor, in his favor. On the contrary, the petitioner has been subjected to harassment when he visited the office of the respondent number 2. Stop disputing the said submission. Mr. Das and counsel appearing for both the respondents. There are 2 respondents here.
On the earlier
one has been replaced by respondent 2, my lord. Now the respondent 2 is the chief
Appearing
executive.
for the respondent submits that he be granted 1 week's time to obtain updated instruction and appraise this court as to the steps that have been taken by now for compliance of the court's order. The request of Mr. Das, this contempt case is directed to be listed again on 24th of March 2025 as a fixed item for orders.
Lordship, my submission regarding the coming of petitioner to the office of the restaurant number 2, misbehaving with her, that may also be. Yes, Lord.
Please don't tell us how to write judicial order.
No, Lordship. I'm just pointing out. Lordship. I'm obliged.
Yes.
Your Lordship, I am extremely sorry, Your Lordship. In my
And the
copy,
prayer
that
of
is
Mr. R. Majumdar,
changed.
counsel for the petitioner.
Yes,
1 week
yes,
further
I will
time. How
enter.
much? 2 weeks further time is granted for filing amended cost item. Let the matter be listed thereafter.
Obliged.
41 and 42, I think that's S. Sharma. What is this? What is the matter about?
For the AG, my lord, I have no role to play. Probably termination matter, my lord. Apprehending.
The payment of wages, lordship.
Sure.
The peon of the foreigner tribunal manager, lordship.
Yes, Mr. Payang, you have terminated.
My name is Lipshut, but I have not been terminated.
Acha, we take down non-appears for the petitioner when the matter is called up. Ms. N. Bhattacharjee, learned additional senior government advocate Assam, Mr. J. Payang, learned SC FT Assam, and Mr. B. Sharma, learned standing counsel for the office of AG ANE are present. Since the petitioner's counsel is absent today, this matter be listed again after the BU vacation.
Last occasion also. The petitioner did not-
Let us see, beyond, he may have difficulties. Let's.
Item 42.
May I please your lordship, as per office noted 8/1/2025 lordship, service reported awaited on respondent number 1 lordship.
You are appearing for?
Lordship, I'm appearing for respondent number 3.
The learned
Against this
counsel for
twice
the
lordship.
petitioner is present. Mr.
On behalf of Lordship T.A. Chaudhary,
Huh?
I'm on behalf of Lordship T.A. Chaudhary.
What about respondent number 2?
No, I'm from respondent number 3, Lordship.
You have to take fresh steps on respondent number 2. Notices return unserved. Have you seen it? I heard Miss
J. Chetri lordship.
Huh?
J. Chetri.
J. Chetri, learned counsel for the petitioner. Also heard Mr.
J. Nabi.
J. Nabi, learned counsel appearing for the respondent number 3. It appears that service report on respondent number 1 is still awaited. Further, notice sent to the respondent number 2 has apparently returned unserved. Therefore, the petitioner to take fresh steps for service of notice upon respondent number 2 by registered post with AD. On the above count, this matter is adjourned for 3 weeks.
Thank you, Lordship.
Item 44.
May I please, as a lordship? My lord, I'm sorry, my lord, we are required to file an, my lord, amended cost title, my lord. And that has been inadvertently not on record, my lord.
How much time you want?
A week's time may kindly be given.
On the request of Mr. A.R. Bhuya, learned counsel for the petitioners, this matter stands adjourned for 10 days so as to enable him to file the amended cost title. Mr. N. Upadhyay, learned standing counsel,
For 1, 2, and 3, Lordship.
Irrigation Department.
1, 2, and 3.
Your irrigation standing.
Lordship.
For respondent numbers 1, 2, and 3, and Mr. C. Barua, learned counsel for the respondent number 4 are present.
All right, Lord.
Obliged.
Item 45.
May it please your lordship?
Yes.
Lordship, there is a delay of around 357 days in revival restoration of the contempt case, lordship.
Contempt case was dismissed.
Dismissed, lordship. Dismissed on 3/8/2022.
Where is the order?
Page 16, Lordship, order is at 17, Lordship.
Yes. So what do you want?
So I want to revive this petition, Lordship. So there is a delay of 357 days, Lordship.
Yes, what is your stand? Ms. Bora? No stand.
Delay can be condoned, my lord.
Don't say things like that. Contempt cannot be revived like this. Just because the expression revive is mentioned, that doesn't mean it is a matter of routine. There is no question of revive. The court has closed their contempt petition. It is not dismissed for default.
Yes, Lordship.
Then you have to file a fresh contempt petition. Today, we don't know who is the officer. You have to demand compliance and then file a fresh contempt petition.
Lordship, amended cost title has been filed in this regard.
Amended cause means on implement.
Implement, Lordship.
When were they implemented? When was the implement made?
Lordship.
Twenty-three,
Lordship,
24, there's an order to
23/9,
implement.
23/9/2024, Lordship.
24.
That order to how it was passed on a disposed of case. How implement can be done in a disposed of case? Where is the order? Let us see.
I think they may file a fresh contempt, lordship.
You just said there is no objection, so where is the order of implement?
Lordship, IA 2356, Lordship, 2024, Lordship.
IA
2356, Lordship.
IA 2356.
It was complete.
Lordship, order dated 23/9, Lordship, on the IA.
So it's difficult because the implement has been allowed in a petition which is still dead.
Lordship,
So there has been no implement here.
no implement, lordship. Otherwise, I am appearing for respondent number 2. I have received instructions also, lordship.
What instruction?
Last para, lordship, may kindly introduce
No,
this?
no, you tell what is the instruction.
In compliance of the same, accordingly, the matter was placed before the second DLC meeting dated 7/10/17. However, as per the minutes of the meeting copy enclosed as Annexure 4, the representation of Ms. Sandana Coach, daughter of so-and-so, seeking for compassionate ground appointment could not be considered and rejected the same as per Principle 6 OM number ABP so-and-so dated 1/6/15, citing reason that the petitioner's mother is a government employee.
So the prayer has been rejected then.
Yes, lordship.
What remains? Where is the contempt?
Let they furnish a copy, Lordship, it will be challenged, Lordship, because what plea has been taken, Lordship, that mother is a government servant, she has also expired, Lord.
Okay. All right, take down. Then we'll close it by granting liberty. I have
Yes,
Mr. S.J. Sharma, learned counsel appearing for the applicant. Petitioner. Also heard Ms. A. Bora, learned standing counsel.
D. Bora.
D. Bora, learned standing counsel, Health Department, Assam, appearing for the respondents. It is submitted at the bar that by order dated, what is the order?
By order dated 5th February 24.
05/02/2024, the representation submitted by the petitioner has been disposed of by rejecting her prayer, and therefore the order dated 26/10/2017 passed by this court in WPC number 7790 of 2016 has already been complied with. Full stop. At this stage, Mr. Sharma seeks leave of this court to assail the order dated 5/2/2024 by filing appropriate proceeding. In view of the above, this IA stands closed with the liberty as prayed for.
Obliging.
This case stands disposed of. Pick the number. ऊपर एक line दिया लगे नामों पे सर. IA has been filed with a prayer to restore contempt case number so and so. Restore / revive.
Lordship, I am appearing on behalf of B. Barua.
Sorry?
I am appearing on behalf of B. Barua.
Yes.
Yeah. Lordship, conducting counsel going to take fresh step upon respondent number 6 by today.
On the prayer of learned counsel for the petitioner, 2 weeks further time is granted for taking fresh steps for service of notice upon the respondent number 6. Let the matter be listed accordingly.
May it please your Lordship. Lordship, filed order dated 10/1/25 of the law of Zimma. So we had provided the correct address of respondent number 3. And as such, it is placed before for amendment of cost title, Lordship. We allowed a week's time.
On the prayer of
Zaid Islam.
Zaid Islam, learned counsel for the petitioner, 10 days further time is granted for filing amended cost title. Mr. D. Bora, learned G. Asan is present on behalf of the state.
Respondent number 1.
State respondent number 1.
Oblige your Lordship.
Item 48.
May please, Lordship. My lord, order, my lord, passed on, my lord, 1/2/24, my lord, page 15, operative person 10, page 24, my lord. Respondents are directed to first appoint, my lord, appoint the petitioners. Thereafter, verification should be done, my lord. But thereafter, they file review petition, my lord. In the review petition, they submitted that verification was already completed, my lord. After completion of the verification, my lord, they have appointed others candidate except 4 candidates for CRPF, my lord. Petition number 2, 4, 10 and 13.
1 minute, 1 minute. Who is appearing?
I am for respondent number 2 and 5, my lord. Director CRPF and CSF. Now 4 candidates were left, my lord.
Wait a minute.
Yes.
And who is appearing for the other respondents?
My lord, C, my lord.
Achha, what about 1, 4 and 6?
They have not appeared.
SSC, 1 is SSC, 4 is SSB, and C is laboratory.
A matter pending of respondent number 2, my lord, now, my lord.
My lord, just I am placing only, my lord, regarding these 4 candidates, my lord. Others were already appointed. Only 4 petitioners, petitioner number 2, 4, 10 and 13, my lord. On 28th February, my lord, after completion of the order result, my lord, being the nodal agency CRPF, my lord, they send name of some candidate for further verification, my lord. Now on 28th February, my lord, one result has come, my lord, they have wrote to the SSC authority that this 28 candidate, there are only 4 other petitioners, other candidates are there. They all are found genuine, my lord. Now to declare the result, my lord, this now SSC will do, my lord. Actually, after the verification, for re-verification, few candidates, these petitioners and some other candidates were again same. But I have a tick mark, in the right side, serial number 19, 20, 25 and 27. These are the petition number 4, 10, 2 and 13, So they were all found genuine. Now only to give appointment SSC, it will take some time. Others, all the contempt petitioners were appointed,
So where is the order of the court?
Yes, my lord. Page 15, my lord, sanity, over person page 23. It's long back, my lord.
Subsequently, we find the
Page 22, my lord.
review petition also,
01/02/2024. Thereafter, they filed review, my lord.
All right, so petitioner numbers
2, 4, 10 and 13, Others were appointed, One candidate is not appointed. He is from, but he may be not coming. Petitioner number 9, Devojit Datta from SSB. He perhaps has not joined. He has joined some other. Regarding his information.
matter.
Yes.
And you are representing, they are going to be appointed by which agency?
CRPF, my lord.
No, appointment will be given by SSC. CRPF will, they will be appointed at CRPF, but appointment order will be passed by the SSC.
SSC's job is only to select, not
Yes,
appoint.
yes, yes. CRPF will happen, my lord.
Appointment.
Then why are you saying SSC?
So sorry, they have written to the SSC authority to declare the result. Now this declare the final result as found genuine, and then appointment order will be passed.
All right, you take down. Mr.
HR Ahmed.
HR Ahmed, Learned Counsel for the petitioners. Also heard Mr. RKD Chaudhary, Learned DSGI.
Advocate.
Learned Counsel appearing for the respondent number 3. Mr. KK Parasar. Learned Counsel has appeared for the respondent numbers 2 and 5. Service report and respondent numbers 1, 4 and 6 are still available. Mr. Parasar submits that all the petitioners except for the petitioner numbers 2, 4, 10 and 13 have already been issued appointment order. After
only regarding 9 also not appointed, because he has not come.
2, 4, 9, 10 and 13. Except has already been issued appointment order. Upon verification of the records, it is found that the respondent numbers 2, 4, the petitioner numbers 2, 4, 10 and 13 have a genuine claim, and therefore their cases are now being processed by
For
taking
appointment.
up the matter with the SSC. Full stop. He submits that order of appointment is likely to be issued to the said petitioners in the near future. Full stop. Insofar as petitioner number 9 is concerned,
Proper
Mr.
instruction
Parasar
is not received.
submits that although complete instructions are still awaited, yet it appears that the petitioner number 9 has not accepted, has not come forward to accept
Appointment.
the order of appointment. Full stop. Taking note of the submission of Mr. Parasar, this matter is adjourned for 4 weeks so as to enable him to obtain updated instruction.
Obliged.
Obliged.
We have to file an amended cost title for respondent number 6. The title was wrong. We have filed that amended cost title. It's on record matters and
We have filed.
notices were issued only to respondent number 6 and 7 at this stage. One of them has, respondent number 7 has filed the wakalatnama, but yet any response to come. We were required to be given the minimum pay scale as per Upenda's judgment.
You are appearing for whom?
Respondent number 7, Your Lordship. Lordship of instructions are still awaited. Some time may be granted.
Wakalatnama was filed in
Filed.
January. Now we are in March, no instruction. Relevant portion of the order at page 16,
Recently, they have amended the cost item.
not for 7.
6.
Who is appearing for the other respondent?
My notices were not issued because initially this honorable court wanted to see whether the respondent number 6 and 7 have forwarded it to the others or not. That was the order. If Lordship has the order dated 2/9/24. Only 6 and 7 were
What
issued.
about respondent number 6? Who is
Lordship,
appearing?
respondent number 6 has not received the amended cost title till date. No notice has been issued to him.
No, they received the copy, a statement was, Lordship would have ordered it 14/2/25. And the amended cost title, there's an office note, we have filed it. After service of copy on 6.
But Your Lordship, as per my instruction, we have not received.
14/2/25.
So after amended cost, was notice issued to respondent number 6?
No, Your Lordship.
But someone had appeared for respondent number 6 who said that they could not file the affidavit, the Wakalatnama only because the title was wrong and the registry was not accepting it. So there was an order for us to correct the cost title. We corrected the cost title. Yet the Wakalatnama has.
But who was the counsel who appeared for respondent number 6?
Lordship, I will appear for respondent number 6 also. Lordship, we have not filed the wakalatnama. We will file the wakalatnama.
File it.
Yes, Your Lordship.
2 weeks. Otherwise, we'll have to call them to the court.
Yes, Your
And 7 has not filed any response.
Counsel is present for the petition. On the request of Miss
D. Jean.
D.
Jean, yes.
Learned counsel appearing in this case for respondent number 6 and 7.
Yes.
2 weeks time is granted for filing wakalatnama and also for obtaining instruction as to the steps taken by those authorities for compliance of the court order. This is the matter again after 2 weeks as a fixed item.
Yes, Your Lordship.
May I please, Your Lordship?
Yes.
As per office note dated 11/3/2025, EDICAS has been received back in response to respondent number 2 and respondent number 1 and 3 till date EDICAS not received yet.
Anybody appearing for respondent number?
I have started to appear. I have filed it. Started on.
Acha, your name please?
A.K. Hannan, madam.
Mr. A.K. Hannan.
Yes.
Learned counsel is present on behalf of the petitioner. Mr. S.K. Mehdi, learned counsel, submit that he has instructions to appear on behalf of the respondent number 2 and prays for 2 weeks time to
3 weeks, madam.
3 weeks time to file affidavit. Office note indicates that service report on respondent numbers 1 and 3 are still awaited. Awaiting service report on respondent numbers 1 and 3. Let this matter be listed again after 3 weeks.
My lord, in read petition, my learned counsel appear for all the respondents.
That is another matter. Contempt case, we cannot force him.
Well, Your Lordship.
Lordship, on the last occasion, notice was issued.
We have not received extra copy. I am for respondent number 1 and 2. Seat corpor is the competent authority to apprise the court. Seat corporation is a main party, Lordship, to apprise the court.
So have you taken steps for service of notice on respondent numbers 3, 4 and 5?
Yes, Lordship.
You have to take steps.
Extra copy, Lordship.
Yes. Heard Miss G.
Zibora.
No.
R.K. Talukdar.
Mr. R.K. Talukdar, learned counsel for the writ petitioners, Also heard Ms. G. Bora, Learned Standing Council, Agriculture Department, Assam, who submits that due to want of extra copies, she could not obtain instruction for filing affidavit in this case. In view of the above, 2 extra copies of the writ petition be furnished to Ms. Bora within 3 days from today. Petitioner to also take steps for service of notice upon the respond numbers 3, 4, and 5 by registered post with AD in terms of the order dated 10/1/2025 passed by this court. Let the matter be listed again after 4 weeks with appropriate office note. Line number none has appeared for the respond number 6.
My lord, in this matter, I have not received instruction. I need some time to receive instruction, my lord.
What is this matter?
Sir,
What is this IA about?
IA means lordship here in this case, this honorable court, at the time of issuance of notice of motion has passed an order with regard to the transfer order, repeated issuance of transfer order. So the order has been passed by this honorable court on 23/9/2024 to maintain status quo as regard the posting of the petitioner be maintained. Now, what has happened, lordship, this petitioner is there in the Dholai PHC, but there is no such order to continue his service in the Dholai BPHC. So I'm just in a confused state of mind where to go. Because my transfer order initially to Hailakande, then to Majuli, that has been put to challenge, and this honorable court has passed an order granting status quo. So I filed an IA, giving a necessary direction to at least to clarify whether I can continue in service in Dholai PPSC or not. We will obtain
my
the
lord, if
instruction.
status quo has been passed, obviously, my lord, that will be.
But I have not been
carried
allowed
out, my
to-
lord.
All right.
But in the entire matter, my lord, I have sought for instruction, my lord.
What about the IA?
IA, my lord, because his main issue is that, my lord, after passing of the status quo order, no fresh order has been passed.
But where is he today?
Exactly.
You obtained instruction.
Yes, my
You
lord,
pick
I
it up
obtained.
on Monday.
Monday.
Friday or Monday?
Next Wednesday, my lord.
All right, whatever it is. Heard Mr. S.P. Chaudhary,
Yes,
Learned
please.
Counsel for the applicant. On the request of Mr. D.P. Bora, Learned Standing
23.
Counsel for the Health Department. This matter is directed to be listed again on 26th of March 2025 as a fixed item, along with the connected writ petition, so as to enable him to obtain specific instruction and appraise this court as to the present place of posting of the petitioner in the light of the order dated
23/9/24, lordship.
23/9/2024 passed by this court.
Yes, lordship.
Court's order is 23/9/2024.
23/9.
Yes, my lord.
Okay.
God bless you.
All cases over.